First District Court of Appeal is now in session. All who have business before this court draw near, give attention, ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. Please be seated. Welcome to the First District Court of Appeal. We have one case on the docket this morning, Stony Mountain LLC versus Freestone Enterprise and various others. The case number is 22-2690, and that's the only case we have, and we've allocated 15 minutes per side. Counsel, are you ready?
Yes, sir.
Okay. Are you going to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
5 minutes. Okay. You may proceed.
May it please the court, my name is Christopher Zacharias. I represent Story Mountain.
Mr. Zacharias, would you pull the microphone a little closer to you? Thank you.
My name is Christopher Zacharias. I represent the appellant Story Mountain LLC, who's the assignee of Iberia Bank, who's the judgment creditor below. Florida law permits a creditor who holds a money judgment against a defendant the remedy of a post-judgment receiver. And so the discrete issue before the court today is, does a judgment creditor who holds a money judgment against a defendant need to show more than an unsatisfied writ when it applies for a post-judgment receiver?
Let me just go ahead and ask a question on that first point that you've made. So when you say Florida law permits it, tell me what you mean when you say Florida law permits that.
Sure, Your Honor. The Warshaw v. Price allows for a receiver over an individual. There's also a statute that codifies, it's common law and codified with regards to a receiver in the context of a post-judgment money judgment judge. Additionally,
So are you telling me there's a statutory provision that provides this authority?
as it relates to judgment debtors that are corporations, yes, there is, Judge. But as it relates to the debtor, which is in this case, no, Judge, it would be common law.
Is there anything other than Warshaw that supports your position?
It would be the equitable powers in 5629, Judge. 5629 affords a creditor broad, it's supposed to be construed liberally, and to afford judgment creditors the broadest possible remedies, including a judgment, post-judgment receiver.
So Warshaw seems to run in opposition to Granada Lakes Granada Lakes Village out of the Florida Supreme Court, where the Supreme Court said that equitable receiverships are a creation of common law which should be reserved for cases involving fraud, self-dealing, or waste. So how do you reconcile Warshaw with that Supreme Court case?
Sure. The Granada case was a pre-judgment case, Judge, so it was not that they were executing on a money judgment. And so specifically, Warshaw is a money judgment. So it's by execution. And so that's where the key distinction happens. And the reason why a lot of the pre-judgment cases say it's a drastic remedy is because you're basically infringing on a person's property rights that have not basically been adjudicated. At this juncture, Mr. Spring, who's a judgment debtor, owes over $2.5 million for over 10 years, hasn't paid it. So as with Warshaw, the same reasoning applies. We could show up with the sheriff to his home and start levying on personal property.
Well, that seems to be the remedy that you should be doing. You've got a writ of execution. Go get the sheriff to execute it.
It's not mutually exclusive, Judge. Just because you can skin the cat in multiple ways doesn't mean that you're now precluded from the other remedies, Judge. And specifically, Warshaw says that you're allowed to have a receiver, or you can go in and take the receivables. So because we're choosing now the less drastic remedy to marshal the assets.
Why do you consider it to be a less drastic remedy? I mean, aside from the uncited proposition in Warshaw, I mean, why is it a less drastic remedy to subject someone to a guardianship of the court, basically?
It's not a guardianship of the court, but
Well, who does the receiver work for?
the receiver is an arm of the court. It's
Right.
a fiduciary.
Right, and you'd have the receiver get into all of the debtor's business and have the court take control of all his assets. Why is that a less drastic remedy?
Your Honor, it would be, just to clarify, it would be taking over the non-exempt property of the debtor and then to marshal them.
Sure, and what specific property, because you didn't identify it in the affidavit, so what specific property were you asking the court to take control over?
Sure. So it's the receiver normally has broad powers to marshal all of the non-exempt property.
And where do you get that from, that proposition?
That would be from Leal, Ross Williams Leal at 337 Southern 3D 523, and it specifically says that the purpose of a post-judgment receiver in the context of a money judgment is, quote-unquote, marshaling and managing the debtor's assets to pay the outstanding judgment, Judge. So it's not...
But that's when the assets are being otherwise wasted or distributed or being used to avoid the judgment, isn't it?
No, that's not accurate, Judge. The Leal case is a post-judgment case that was a money judgment entered against a corporation, and...
Well, that's a statute, though. There is a statute that provides for receiverships. There are several statutes that provide for receiverships for corporations.
Correct.
I'm talking about an individual.
Yes, Your Honor.
Here. So what case do you have, preferably from the Supreme Court, since the Supreme Court has been talking about this since 1909 at the least, that a receivership is a drastic remedy whenever it's used as an equitable tool?
I would
It should
disagree.
be a
that
last
it's
resort type thing.
I would disagree that it's a drastic remedy as a post-judgment.
You disagree with the Supreme Court's characterization of it?
No, not as a pre-judgment remedy. I would agree 100%. It's a
Right, but
drastic
this
remedy.
is a common law remedy, and it's inherent in the powers of the court, and it's inherent in the powers of the court to protect creditors when there's concern that the assets are being wasted or taken from access from the creditor.
I think the court is talking about the Colley case, but that's a pre-judgment case, Judge. And so I don't know of any...
What is the difference?
The difference is that there's now a money judgment that's been liquidated, and my client has a writ of execution, and under the rules, we can execute on all non-exempt property, Judge. So,
Right, which you haven't done, apparently.
Well, because there's certain causes of action that are so personable that we cannot pursue. I can give an
So
example.
you're going to have a court, and I saw this in your argument in the transcript, so you're going to have a court appoint a receiver so that that receiver can sue other people?
Yes, Judge.
And what on earth, where do you get that from as a possibility?
That happens all the time in receivership. They file
Really?
claims against a breach of fiduciary duty claims, negligence cases.
Well,
DMO
breach of
cases.
fiduciary duty, those are statutory causes of action that actually the supplementary proceedings statute actually provides for,
Correct. And so...
which you haven't pursued.
But there's certain actions that we cannot take under 5629 because they're so personable to a debtor that they cannot be assigned. For example, a malpractice case. The court will not be allowed to sell or assign a malpractice case to satisfy, our judgment. So the receiver would bring it on behalf of the receivership estate, and then it would then go to pay the creditors, Judge. So there would be no way. I think that was one of the questions that the trial court had is, hey, why don't you pursue those cases yourself? It would be impossible for us to bring those. We don't have standing to do that, but the receivership estate does.
Why should you not be required to at least identify some property or assets that the receiver would be responsible for managing?
Because the receiver, so I think it's a point of clarity, the receiver is not over a property, but it's over the debtor, and the debtor's non-exempt property. So as the moment that there's a receiver's in place, it creates a receivership estate, which then becomes what goes into the receivership estate would be all the non-exempt assets. The debtor will not be without remedy. He will still have all his statutory exemptions. For example, if a receiver would like to dispose of a property, let's say real property for sale, the debtor still has the ability to claim, hey, that property is exempt. It's my homestead, 222, section 222. You can't sell this. And the court will have a hearing, and if it's determined that it's exempt, the receiver is not entitled to marshal that asset, Judge. So I think this is not a free-for-all. This is very orderly, and it allows the receiver to take all of the non-exempt assets and marshal them in a manner which would actually give, more money to the estate. For example, if we were to then levy on real property, it's going to be basically a fire sale, and then less money is going to go to satisfy our judgment. So it's actually in everybody's best interest that a receiver do it in an orderly fashion.
Aren't you really asking for an appointment of a receiver to do the job that you're supposed to be doing?
No, Judge.
Because, you filed the motion asking to open up supplementary proceedings under 5629.
That's correct, Judge.
But you didn't file an affidavit identifying any, you mentioned in your argument that there's, over $1 million in cash or
Yes,
sitting
Judge.
around somewhere?
So there's money sitting in a corporate account between him and his partners, and they're refusing to distribute because of certain reasons. And
So there is an interest in property that he has that you're contending that's in the hands of another party, right?
No, Judge.
So what are you saying?
Because it belongs to the corporation.
Well, that's in the hands of another party, and he
Yeah, but it
has
does
an
not-
interest in that, right?
But it does not belong to the debtor at this juncture until there's a distribution, Judge. So I don't,
So it's not accurate to say that he has $1 million in cash lying around that you're trying to get at?
within a corporation that is not in his name personally. That's
So then
correct,
it's
Judge.
not his?
It's not in his
Okay.
name personally. No,
So-
that's correct.
So what are you trying to get at? I mean, this is the problem. You're asking a trial judge to appoint a receiver to do some unspecified work to investigate, like, whether there's other assets that you can go after instead of, did you take a deposition of him? Did you take discovery to find out where his assets are?
We have taken, I'm into my rebuttal time, but just to answer the court's question, we have taken several subpoenas into financial institutions and have gotten post-judgment aid execution discovery. But just because we haven't taken a deposition does not mean that we're not entitled to a receiver. Like I said, it's to marshal all of the non-exempt assets. It's not one particular asset, Judge. And so it's not a free-for-all because the receiver is guided by the order, and the order is going to set bounds and his duties and scope. And so it's not what the court may think, that it's this, free-for-all, Judge. And at any time, the receiver as a fiduciary will look into the assets and potential cause of action. If there's nothing, it'll report back to the court, and the receivership will be closed, Judge. If there's no other questions,
Did you get an answer?
Yeah, I don't want to just.
Could you repeat the question, Judge?
No, that's fine. I'll just tell you, my point in asking was under 5629, it's actually very specific as to what it allows, what the purpose of 5629, despite what you said in your argument to the trial court. It's not just to open up sort of this broad range proceeding where it'll let you do anything, and notably 5629 doesn't specify receivers. But what it does allow you to do is file a notice to appear or have a court issue notice to appear to a non-party that you said is holding some of the debtor's assets, and go after that and give the debtor an opportunity to defend against that as to why you should get a judgment against those additional assets.
So 5629.
And I haven't seen anything that you've done to pursue actual supplemental proceedings under 5629.
So 5629 is not only limited to the notice of appear, which is subsection 2 that Your Honor.
Where do you get that from?
The exact circumstruction of the statute, Judge. That 5629 also allows for the appointment of a special magistrate to examine the judgment debtor. That has nothing to do with a
In
notice.
connection, no. It actually is all in connection with what's provided in subsection 2.
Your Honor, 5629 allows broad remedies, and there's nothing, 5629 or the enactment of 5629 doesn't abrogate any common law rights that a judgment creditor has under Warshaw for the appointment of a receiver, Judge. So irrespective of
Does the 4th DCA have the power to establish a new right just by declaring it?
It didn't establish a new right.
Well, it didn't cite a single statute or actually a single case to support the proposition that you're citing it for.
Because it's a common law right to have a receiver, Judge. It just clarified what is the threshold for the appointment of a receiver.
All right.
If the court doesn't have any, I'd like to, I'm over my time, I apologize.
And I'm going to give you some more time. We used up about 3 minutes of your time. We're going to give you back 2 of those. And of course, Mr. Rivers, you have an additional 2 minutes if you need to use it for some
I
reason.
appreciate the court's time.
Okay.
Morning, Your Honors. May it please the Court, Dylan Rivers on behalf of James, or Jim Springer, as you may see him referred to in the papers. Respectfully, we would submit that Story Mountain is wrong on the law, and in addition to that, this record is without any facts to support the argument that the trial court abused its discretion in denying a receiver here. according to Story Mountain, it didn't have to make any sort of factual findings to justify the appointment of a receiver. Story Mountain's position is that it's entitled to a receiver over Mr. Springer, an individual, not a corporation, without identifying a single asset or other possible source of recovery to satisfy its judgment, much less demonstrating that any such asset was subject to loss or forfeiture or waste. Story Mountain says that it's it is not required to demonstrate anything other than having an unsatisfied writ of execution. I'm not aware of a single legal authority for that proposition, at least in the context of an individual judgment debtor.
Well, they cite Warshaw, and Warshaw seems to say that a receiver can be appointed in this situation. It may or may not be an outlier, but we don't have a case that says one way or the other out of the first DCA, so arguably we could follow Warshaw if we thought it was persuasive.
Well, to your point, Judge, when it says that a receiver could be appointed in this situation, I think that calls into question what this situation is. And if you drill down into Warshaw, it's admittedly a very short case. It consists of 3 paragraphs, very little analysis. But if you actually read into what the case says, the first DCA, the fourth DCA states, and I'm quoting, it involves, quote, a defendant who carries on a business as a sole proprietorship. Now, there's no analysis in the case getting down into the weeds of this, but as the court's aware, when you operate as a sole proprietorship, you don't have the protections of corporate law or LLCs or anything of that nature. So essentially, the individual's business operations was the individual, and the assets belonging in those business operations were assets of the individual, and they were treated as such. And so the court went on to say that a receiver was being appointed to, quote, take charge of the debtor's accounts receivable. And that was perceived by the court as being a less harsh remedy than sending the sheriff out to levy against all of the property of the judgment debtor in sight, thereby effectively putting the debtor out of business. So the receiver would take over the accounts receivable of this sole proprietorship business to satisfy the judgment instead of taking all the property that was used to operate this business and shuttering it. Because putting the debtor out of business benefits no one. I mean, the debtor loses his business and the creditor loses the receivables that business generates to pay the judgment. So it was I'm sure that the individuals in this case might have characterized it differently, but it was a win-win to the extent there was one in that situation.
Was there a receiver appointed over an individual, like the appellant here wants to have appointed?
If I'm understanding,
In Warshaw, I'm sorry. In
yeah,
Warshaw.
if I'm understanding your question, Judge, yes, and there's
Or was there the appointment of a receiver in the very, very traditional, historical conception of it, which is a receiver of a particular account, actually, to collect on monies being paid into that account?
If I'm understanding your question correctly, Judge, yes, there would be appointment of a receiver, but here we go to the aspect of why it is so critically important for a trial judge to be able to fashion an order that guides and directs the activities of a receiver.
Right.
As the court's already pointed out, this is a common law receivership that's in question, not a statutory one where you would be checking boxes of whether certain criteria were satisfied. In a common law receivership, it would be incumbent upon a trial judge to enter an order that says, I am hereby appointing a receiver to conduct the following activities. I mean, a receiver doesn't get to have a free-for-all. A receiver has to be tasked with certain activities and given certain authorities that it would not otherwise have as just a walking around individual. So to your point, Your Honor, I think I obviously haven't seen the order that was entered in that case, but what I would
Well,
have
but Judge Stone talks about it in his concurring opinion in Warshaw. And the point of my question is, I don't know how far back you went looking at what the purpose of a receiver is, or even what the term receiver actually refers to historically. But it's different than just a trustee or a fiduciary. It's, I don't know if you've noticed historically the Supreme Court decisions of this state going back to 1909, in the context of mortgages in particular, the receivers were appointed to where rents were being used to secure the mortgage, and a receiver was appointed to receive those payments to secure and protect the mortgagee in those situations. Did you see anything different than that concept for an equitable receiver?
In a general sense, no, and I do not disagree at all with your historical explanation, but it sort of puts the fine point on the fact that Story Mountain hasn't even identified anything here for the court to direct a receiver to go receive these rents, go receive these accounts receivable, marshal these non-exempt assets, go manage this property, go to make sure that the judgment debtor isn't diverting these funds for other purposes or wasting the potential to satisfy a judgment. They haven't pointed to anything. There's not a single thing in this record other than an unsatisfied writ of execution. And returning to my original point, I'm not aware of a single authority in Florida.
Well, I think his theory is that once the receiver is appointed, they can go forth around the countryside like the 47th Ronin and seize whatever needs to be seized.
And I'm not sure I can point to you a case that says that isn't the law, but I also can't point to you a case that says that is the law, that a receiver should have carte blanche authority to go grab. I mean, to use a perfect example, which frankly would apply here because you are dealing with an individual debtor. I mean, if you go grab everything that's not tied down, how much of that is TBE property? I mean, that's not subject to execution. I mean, there have got to be some parameters for how a receiver operates, and I believe those parameters have to be based on a demonstration to a court that here are these assets that we've found through subpoenas, through depositions, through any number of things. Here are these assets that we've found. For whatever reason, we are not receiving the income, the rents, the whatever from this, or we would like these to be liquidated, or whatever the case may be. We just don't have that. We don't have a showing of anything. I mean, the record literally has nothing other than an unsatisfied writ of execution. In the hour-long special set evidentiary hearing, there was no evidence. I mean, there was not a witness presented by Story Mountain, a document. There's nothing in the record, and it was all simply an exercise in pointing to Warshaw v. Price as the sole basis of saying, we don't have to demonstrate anything other than an unsatisfied writ of execution. And again, I just don't think that's the law, and I think a close reading of Warshaw reveals it to be a case that wasn't wrong, but a case that was different, a case that involved a business, now albeit a sole proprietor, an individual, but it was a business, and the court appointed a receiver to manage that business and to take its accounts receivable so that they weren't wasted or absconded with or what have you, that they were used to satisfy the judgment.
Is there even a majority holding or a majority opinion in Warshaw?
That's a great point. Great question, Judge. I don't know that I looked that closely, but
I mean, Judge Farmer pontificated in his uncited, an opinion that doesn't cite any actual statute or case, but Judge Stone does, and actually goes into some detail as to what was actually going on. I don't know what it means to say concur to note, which is how Judge Stone starts his opinion. But I'm just curious, what do you perceive to be, if there is a majority opinion, what is that holding?
I think, that although it wasn't said in so many words, I think what you can take Warshaw v. Price to mean is that under those particular facts and circumstances, the Court of Appeal found no abuse of discretion in the trial judge appointing the receiver under those facts and circumstances. I don't know that that can be translated as a holding with general applicability of any post-judgment receivership over an individual. Again, if you get down into the weeds, whatever the holding is, if you get down into the weeds, there's just an enormous amount of factual dissimilarity with this situation. There's not even an allegation, much less a demonstration that Mr. Springer operates a business through as a sole proprietorship, that he has accounts receivable, he has rents, that he has any of these things, at least in his own personal name. And to the extent that, that there are other issues they want to explore, to the point that was made earlier, they haven't done so. They haven't taken Mr. Springer's deposition. They haven't gone down any of these other rabbit trails that might be available to them. Instead, they want to, and the point was made earlier, they want a receiver to do their job. They want a receiver to essentially act as a collections agent, and that is not the purpose of a receivership. I mean, again, the court would have to enter an order directing a receiver to do something. And I don't know that I've ever seen a receivership order that says, go find stuff that these people can levy on. That is exceedingly broad, and that's frankly their job. They have Chapter 56 to avail themselves of quite a number of remedies, and they haven't done so. They skipped right to, please appoint us a receiver because we can't satisfy our writ of execution. Well,
Everybody, I think, agrees that our review here is for an abuse of discretion. You agree with that, right?
Certainly, Judge. Yes.
So usually when we're reviewing things for an abuse of discretion, it's because there's judgment. There's a judgment, meaning an exercise in judgment from the trial court. The trial court has to make a decision and looking at this particular circumstances and exercise their judgment as to the particular facts, to whether or not to, in this case, appoint a receiver. So why couldn't we just resolve this case on that standard and say, look, based on these circumstances, it was a reasonable exercise of that judgment, and and therefore wasn't an abuse of discretion?
Well, I think that's exactly where we are, Your Honor, is that based on the record, I'm not even sure there were disputed facts or anything for the court to have exercised a bunch of discretion over. Quite frankly, the standard that's being advanced by Story Mountain wouldn't really involve discretion at all. It would be, we have an unsatisfied writ of execution, give us a receiver. That's more like a ministerial act than a discretionary one. But to the extent that the court was called upon to exercise its discretion, there were no facts presented for the court to weigh and balance and figure out whether a receivership was justified. And if so, what should the receiver be charged with doing? There just isn't anything like that.
Which is a slightly different thing, right? Which is to say that the trial court could not have, under these circumstances, the way this played out, granted the request for appointment of a receiver, right? So then it would be, which I think you argue in your brief, that it would in fact be an abuse of discretion to have appointed a receiver.
Correct, Judge. What we effectively said is, I just said it in reverse. There was nothing for the court to exercise its discretion over. I think the more accurate way to put it is, it would have been abusive, on this record, it would have been an abuse of discretion to appoint a receiver. A receiver over what? To do what? To be tasked with what? Again, I think it's essentially being called upon to do the job of Story Mountain itself and its legal team, and that's not the purpose of a receiver. The final point I'd want to make in my last few minutes is that, Warshaw versus Price isn't the full end of the story. There is a subsequent case that we've cited in our briefs, U.S. versus Kramer, or U.S. Bank versus Kramer, and it's one of the few cases that actually gives any analysis or explanation of Warshaw versus Price. And in U.S. Bank versus Kramer, the court said, yes, things are different in a post-judgment setting. You don't have the concern of going around and exercising a property interest over things that you would pre-judgment, because post-judgment, there would be a right to levy. But there still has to be a showing. There still has to be some impetus for the court to appoint a receiver to go do these things. Otherwise, they should just go levy. And I think that Kramer, while obviously different, and as Story Mountain points out, it was a post-judgment mortgage foreclosure. So while different on that metric, I don't think the analysis is different. I mean, the difference is that in a foreclosure, and by the way, this case originated as a foreclosure, but obviously that property is long gone now. But in the Kramer case, there still was a piece of property. And to your point earlier, Judge, the receiver was called upon to, I'm sure, collect the rents and do whatever needed to be done to manage the property and make sure the asset wasn't wasted. But the critical difference in my mind is not the fact that it's a mortgage foreclosure. The critical difference is there was an asset. It's obviously a no-brainer in a mortgage foreclosure because you have a real estate collateral, but there was an asset.
And there's more than just the fact that there's an asset. There's an asset that the court had concern was going to be wasted if the court didn't intervene and do something to protect. And it's equitable because it's protecting the equity interest of the creditors in that instance.
Exactly where I was going, Your Honor. That case had two things we don't have. It had an identified asset, and it had a concern that it was being subject to waste or deterioration. And we don't have any of that here. You can't make a case for a receivership to marshal assets and protect assets or liquidate assets if you haven't even identified the assets. We're at a place where I don't even think, again, that there was discretion for the trial court to exercise. It would have been an abuse of discretion to have appointed a receiver based on this record.
And in a supplementary proceeding, isn't the obligation, it's the creditor that opened up the supplementary proceeding or like try to take advantage of the statute or the proceedings that were provided in the statute. Do you disagree, or what is your thought on the reading of, isn't everything that you need to know about what a supplemental proceeding is in subsection 2, basically?
Sure. Now,
In terms of it's designed to, if there are, because obviously if there's an asset being held by the actual debtor, you have execution, you can go after it. The concern is what about assets that are given to others and are being held by others? How do you get after that? Isn't that the point of that proceeding?
Sure. And
was
the
anything
trial
done?
court did grant proceeding supplementary. They can start doing whatever they want to do to exercise their rights under that statute. They haven't done so. And I think I'm above my time. Thank you.
Thank you, Judge. I wanted to touch upon Judge Long's question regarding the abuse of discretion. At the time that this was filed and heard before the trial judge, the only case that was binding on the judge was Warshaw v. Price. And it would be an abuse of discretion when they don't follow the correct law, which is the unsatisfied writ. In fact, that's our position. And in fact, all the facts are stipulated to basically that there's an unsatisfied writ. So I think the court alluded to that there really is no discretion at that point. So it was an abuse of discretion to deny it when under Warshaw all you need is an unsatisfied writ.
What is it?
Go ahead.
Where in Warshaw do you find that holding? Like where in Judge Farmer's opinion does it declare that there's a right to a receiver post-judgment?
Well, generally, and I can, Hamilton versus Flowers allows for a judgment, a receiver over an individual. But as
Allows is one thing, but
Yes,
you're claiming an entitlement, and notably
Correct.
you did not ask for a mandamus writ from us. If you're claiming that it's a clear legal right that the trial court did not grant you and that this is basically ministerial, which I think you might be arguing, you haven't sought a mandamus. You're appealing, which puts it in an abuse of discretion kind of category, and I'm trying to understand how you resolve the tension between discretion and a right, which I still don't even understand where you're getting the right from. But
Sure. The Warshaw opinion specifically says the only exigent circumstances we need is the unsatisfied writ. You don't need anything else. And so just because we can levy doesn't mean that we have to levy first, then to be able to get a receiver.
But that's reviewing whether the trial court abused its discretion in appointing the receiver, and Judge Stone adds a little bit more detail and actually cites a statute and a case even, and remarks that in that circumstance, the judge obviously had a reason to appoint a receiver. And it seems that from the detail that Judge Stone provides that there is an account with accounts receivable that the judge appointed a receiver to take control over and manage the monies coming in. That's a far cry from establishing that there's just this right to have a receiver appointed at any time at the request of the creditor.
Well, I think it's a remedy that's allowed for the creditor. And so at the time, basically, the trial court started legislating from the bench, although this court may not agree with Warshaw, it's free to disagree and certify conflict with that proposition that.
Well, what would the conflict be with? I mean, that's what I'm asking. What is the actual holding, and if you could actually quote something from Warshaw, I mean, what is the actual holding that you would say that if we affirmed in this case, that would be conflict with Warshaw?
We find that there's no error in the trial court's decision to grant a receiver over the judgment debtor's property, and it goes on to say that the unsatisfied writ was all the exigent circumstances that he needed. The trial court found in denying our motion is that we have not provided sufficient circumstances. This is the circumstance. The exigent circumstances is the writ of execution, Judge.
But there's a specific property in Warshaw that they were addressing.
But this is not a receiver. We're not seeking a receiver over a specific property.
Right, but you're relying on Warshaw to establish that this trial court, that the court just almost as a matter of law erred because it didn't grant it, even though you didn't specify a particular property, and you're relying on Warshaw, which involved a specific property.
Judge, I don't know of a particular case that is post-judgment with a monetary judgment that is a seeking a relief over a receiver over the debtor instead of over individual property. But the proposition, like the court actually noted, is that the receivership is over the debtor, not over the property. That's not what we're seeking. So, Judge, what we would be asking for this court to do is to reverse and remand for the entry of a receiver and to hold a hearing to give the scope, duties, and powers of that receiver, because a receiver is only empowered by the rights provided by the court, Judge. So what what the debtor was alluding to is, hey, this may be TVE property. All their rights are preserved. They can make, hey, this is not exempt property. You can't marshal this asset. So this is not an issue where, the debtor is going to lose any of his protections under the law. And so I think that may be one of the hesitations that the court would have. And it may sound kind of draconian, but the trial court was not in a position to start legislating from the bench at that point. We have an unsatisfied writ. Just because we can pursue other remedies, there are certain causes of action that we cannot pursue, and they have to be pursued by the receivership estate. And if there's nothing to pursue, then it reports back to the court. That's what a receiver is. It's an arm of the court, and it's a fiduciary.
Thank you.
If the court has no other questions, that we would rest on our briefs.
All right, thank you both for your arguments today. We're adjourned.
All rise.